In a recent development that has sparked widespread discussion and debate, the Supreme Court has aligned with the Trump administration, allowing the mass dismissal of tens of thousands of probationary federal employees. This decision comes after a lower court had initially blocked these firings, citing the lack of standing from the plaintiffs, which comprise 9 nonprofit organizations. These organizations had been advocating for the reinstatement of the employees, arguing that the dismissals were unjust. From an optimistic perspective, this ruling, while controversial, presents an opportunity for revisiting and potentially reforming the policies surrounding probationary federal employees. The current framework, which leaves these employees without the robust protections afforded to permanent federal workers, is a topic ripe for constructive dialogue. This juncture could serve as a catalyst for lawmakers and activists to push for a more equitable system that balances the need for performance accountability with fair employee protections. Justice Sotomayor and Justice Ketanji Brown Jackson, who dissented, highlight a critical aspect of the judiciary that seeks to protect the vulnerable. Their stance serves as a beacon of hope for those advocating for employee rights, signaling that the fight for justice is far from over. It underlines the necessity for continued advocacy and dialogue to ensure that all federal employees are treated with fairness and dignity. The legal wrangling has its roots in the termination of approximately 16,000 probationary federal employees since President Donald Trump assumed office. This mass dismissal has prompted a wave of lawsuits, primarily from Democratic states, and former employees challenging the grounds of these terminations. The administration has justified the firings by pointing to poor performance, a claim that many of the affected employees contest. While the Department of Justice warns that reinstating these workers could lead to chaos within federal agencies, this situation can also be viewed as a moment to implement more structured and transparent performance evaluation processes. Such measures could enhance trust and efficiency within federal agencies, ensuring that dismissals, when necessary, are fair and justified. In the midst of this legal battle, a federal judge in Baltimore had ordered the administration to reinstate the probationary employees and provide a detailed account of the compliance process. This decision was a glimmer of hope for many, emphasizing the role of judicial oversight in maintaining checks and balances within government actions. The plaintiffs have argued that the reduction in staff has already caused significant harm, particularly in crucial departments like the Department of Veterans Affairs, which struggles with chronic understaffing. This situation presents an opportunity for the administration to address these staffing challenges proactively, ensuring that essential services are not disrupted and that federal agencies are well equipped to fulfill their missions. Similarly, cuts to agencies like the Forest Service and the Bureau of Land Management highlight the need for strategic staffing solutions that safeguard the environment and manage federal lands effectively. By focusing on sustainable staffing practices, the government can ensure that environmental preservation remains a priority, benefiting both current and future generations. The recent expansion of the order by a Maryland judge, mandating the rehiring of terminated employees and imposing restrictions on future mass firings, underscores the importance of adhering to federal laws governing employee removals. This development is a step towards ensuring that the rights of probationary employees are respected and that any future terminations are conducted with fairness and transparency. The Trump administration, represented by Solicitor General John Sauer, contends that court orders should not interfere with federal workplace reforms. While there is merit in allowing agencies the flexibility to determine the best ways to achieve their missions, there is also a pressing need for these reforms to be balanced with accountability and respect for employee rights. As we navigate these complex issues, it is crucial for policymakers, advocates, and citizens to engage in meaningful conversations about the future of federal employment practices. This dialogue should aim to establish a system that supports both the effective functioning of federal agencies and the fair treatment of all employees. We invite you, our viewers, to share your thoughts on this topic. What are your views on the Supreme Court's decision and its implications for federal employment? How do you think reforms should be approached to ensure fairness and efficiency? Your comments contribute to a more informed and engaged community, so please let us know what you think. If you find our content valuable, consider subscribing to our channel for more updates and discussions on important issues. Your likes and comments not only help us grow, but also foster a vibrant community of informed citizens. Thank you for watching, and we look forward to hearing from you.